Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. She points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Hey yo folks, I hope you are having a great time. Here I am using Rumble Studios today because the latest bunch of people who were demonetized on the YouTubes are eerily similar to what I do. Reading documents, covering trials, bad shit happens. So hopefully, this I can grow on Rumble as well, and hopefully Rumble can create a true crime tab or something of the sort to get more viewers over to that segment instead of all the politics. So, good evening, hello, good afternoon if you're in my part of the world, or good morning if you are in the United States, and have a nice evening and night if you are on somewhere in Asia. Why demonetize? Well, it's YouTube have their. I honestly don't know, but if you're on X, you see examples pop up every now and then about people after a decade of producing content on YouTube all of a sudden get demonetized. So, yeah, just covering, using Rumble as a secondary, just in case. So if you don't have a Rumble account yet, and you wouldn't mind the hassle of creating one, I would deeply appreciate you doing so. And let's hold on here. There's something weird. Going on here. Why the this isn't right. No wonder I get No, you asshole. Sorry. No wonder I get so few viewers on Rumble, because Rumble is using the wrong fucking account. They're using my user account, not my channel account. Oh, for fuck's sake, Rumble. Oh, this isn't good. This is horrible. Absolutely horrible. And I can't change it once I get... Can I add a new destination? Rumble. No, already connected. All right, I have to... Well, on my actual channel on Rumble, I have to post this at the correct position. Yeah. All right. Well, hello, folks. Hello, folks. Old fart. Yeah, I'm old. I'm not technical at all. And why can't I change that? Rick. I should be able to just... Nope, wrong. Should be on an actual channel. Yeah, but I can't. All right. What's done is done. What's done is done. All right, folks. What we are going to do today is going through Omar's revenge. And Omar is Mike Marraccini's attorney. And he is very good at it. Let's just say that, because he has this rare ability to inflict snark in court documents and motions that is so hard to detect, but you can feel it. And so we are going to start with Respondent Michael Marraccini's motion for attorney's fees and costs, memorandum of points and authorities. That sounds like fun, doesn't it? Oh, folks, that is good. And once we are through that, we will go for an encore of index of exhibits to respondent's motion for attorney's fees and costs. Doesn't that sound like fun? Well, let's just say, oh, you're in for a treat, folks. You're in for a treat. So here it is. Hope you can see it. The Eagle Law Firm, attorney for respondent Michael Marraccini, Superior Court of the State of California, County of San Francisco. Laura Owens, petitioner versus Michael Marraccini, respondent. Respondent Michael Marraccini's motion for attorney's fees and costs, memorandum of points and authorities. Hearing date, July 20th. So this is in preparation for that hearing. So July 20th at 9 a.m. Notice of motion to petitioner Laura Owens in propria persona. Please take notice that on July 20th, 2026 at 9 a.m. or as soon thereafter, as the matter may be heard in Department 405A of the above entitled court, respondent Michael Marraccini will, and hereby does, move this court for an order awarding attorney's fees and costs against petitioner Laura Owens in the total sum of $109,633.98. This motion is made under Family Code section this and that on the ground that petitioner's request to renew restraining order was frivolous and solely intended to abuse, intimidate, or cause unnecessary delay, and that petitioner has, or is reasonably likely to have, the ability to pay the fees and costs sought. Costs are independently sought under Code of Civil Procedure sections 1032 and 1033.5. Yeah. Within the first few lines of text. He is calling Laura out as a liar, telling the court she has money. She has money. Oh, she has money. She has money. This motion is based on this notice of motion, the accompanying memorandum of points and authorities, the declaration of Omar R. Serrato, and exhibits thereto, the exhibit package filed concurrently, the papers and records on file, and such further argument and evidence as may be presented at the hearing. Yes, folks. Hit the thumbs up. You know, you should know that by now. That it helps the channel. It helps to go through to get it to more people. Memorandum of points and authorities. Procedural history and background. Oh, folks, hold on to your breeches. This is going to hurt Laura so badly that even Ginger Ass will feel it. The 2018 stipulated order. Petitioner Laura Owens filed a request for domestic violence restraining order on January 9th, 2018. Temporary order was issued January 10th, 2018. The parties entered the stipulated restraining order after hearing on or about July 10th, 2018. The stipulated order contained no judicial finding that respondent committed domestic violence. And it's correct. That order is when Mike said, sure, I stipulate to whatevers. Okay, the order is stipulated to. You, Laura Owens, have now a restraining order. But there was no judicial finding of abuse. B, the 2020 renewal. On July 10th, petitioner filed a renewal request. On September 11th, 2020, the Honorable Sharon Reardon, Department 403, held a contested hearing at which both parties appeared pro per. The court applied the reasonable apprehension of future abuse standard and granted the request to renew for 5 years. Example, blah, 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 blah. The record contains no finding of any DVRO violation by respondent. The 2020 renewal was based on petitioner's subjective statement of fear. Oh, I'm so afraid of him. And in California, that seems to be enough in many cases. Regardless of evidence, I'm fearful. C, the 2025 renewal petition. On July 9th, 2025, petitioner filed a second request to renew restraining order on Form DV700. On the form, petitioner left blank section 4A, the box stating, I am afraid or worried that the person in 2 might abuse me in the future. She marked only section 4B, alleged violations. Yeah, because Laura Owens is not the most clever person. Respondent retained the Eagle law firm on or about July 9th, 2025. Between July and October 2025, respondent filed a response to the renewal request with 15 exhibits, an opposition to petitioner's motion to proceed by declaration, a motion to disqualify petitioner's counsel, David Gingerass, a motion to vacate the 2018 order under Code of Civil Procedure, Section 473, motions in limine, a trial brief, an opposition to David Gingerass's motion to intervene and for sanctions, witness and exhibit lists, and supporting declarations. D, October 10th, 2025. Pre-trial motions resolved, trial confirmed. On October 10th, 2025, the court resolved all pre-trial motions and confirmed trial for October 21st and 22nd of 2025. The court denied David Gingerass's motion to intervene. In parentheses, intervention requires direct and immediate interest in the litigation, This matter is from a witness to the litigation and is ancillary, meaning he can't represent a person if he's also a witness, basically. Denied respondent's motion to disqualify a ginger ass without prejudice as premature and ruled the motion to strike and sanction moot. The court further noted that, on petitioner's representation of defective service, respondent withdrew the Code of Civil Procedure Section 473 motion. The withdrawal was a strategic election to preserve the trial dates and avoid bifurcating the proceeding. The motion had been fully prepared, briefed, and supported by exhibits, and remained substantially viable. There's a certain build-up in his language, how he writes. You read something, oh, and it's like, but wait, there's more. And then you get to the next section. Oh, now something more happened. And then, but wait, there's more. And we have 18 pages of, oh, wait, there's more. October 21st, 2025. Life-threatening travel representation. On October 21st, 2025, petitioner appeared by Zoom only and represented to the court that travel to San Francisco for trial would be, quote-unquote, life-threatening. The court admonished petitioner that she had been previously ordered to appear in person and stated her motion was improper and not before the court today. Because no court reporter was available, the court continued the matter to October 22nd, 2025, with both parties ordered to appear in person. The court stated, this court will not extend or continue request to renew restraining order with an indefinite period. Petitioner's October 21st, 2025 email to the court invoking a life-threatening risk representation, supported by letters from a nurse practitioner styling herself Dr. Colleen Green, DNP, and from a Dr. Amr Nassef, is at Exhibit 14. We will look at the exhibits later on. Yeah, here's the thing. Nurse practitioner is not a doctor. Falsely portraying yourself as a medical doctor is medical fraud. A nurse practitioner cannot or is not allowed to diagnose. That's medical fraud. Laura Owens has a tendency to, how do I say this diplomatically? To fuck with people she needs. She basically made this nurse practitioner, drew her in, and then made that nurse practitioner an accomplice, committing crimes. October 22nd, in camera continues to November 5th. On October 22nd, 2025, the court held an in-camera hearing on petitioner's accommodation request. The court noted, quote, the court notes that the request is improper and untimely. The court nonetheless exercised its discretion to grant a brief continuance to November 5th, 2025, and, quote, ordered petitioner to be in San Francisco and to be in the courthouse in person for the trial. There are many minutes from this. There are many minutes from this. Also known as evidence. October 22nd through 26th, 2025, Scottsdale Fall Classic. Oh, here we go. Here we go. Now they are telling the judge, Judge, she claimed to have life-threatening illness. Let's see how life-threatening that really was. Petitioner was as entry number 570 in the 2025 Scottsdale Fall Classic 2 USEF National A-rated hunter jumper competition held October 22nd through 26th, 2025 at Westworld of Scottsdale, Arizona, with an entry closing date of October 6, 2025. Meaning, Laura never intended to go to San Francisco because she paid and registered to a competition on a trial date. The full factual record of Petitioner's competition activity, including her placements and the contemporaneous eyewitness observation of Kristin Hardin, is set out at section 3b5 below. So we will get there. This here is just a summary of what to expect. But see here how Omar draws you in? Because there's oh wait, it's more. Oh wait, there's more. November 5th, Petitioner's non-appearance and dismissal. On November 5th, 2025, Petitioner did not appear. Respondent appeared in person with counsel and associate counsel. The court ruled because of the non-appearance of Petitioner, Petitioner's request to renew restraining order is dismissed. The temporary restraining order against respondent is dissolved. Meaning, on November 5th, any restraining order was gone. The temporary that she had on him for the past 5 years dissolved. No written order was prepared. No, but it was said in court as a court ruling, a judge's ruling. Post-dismissal procedural conduct. Petitioner's post-dismissal procedural conduct is set out in detail at section 3c below. The factual sequence include filings in this court, the California Court of Appeal, the United States Bankruptcy Court for the District of Arizona, and the Maricopa County Superior Court. There is so much to go through. I'm so happy. J. Antecedent criminal proceeding. I hope that is the correct pronunciation. On May 1st, 2025, a Maricopa County grand jury indicted Petitioner on 7 felony counts, including fraudulent schemes, 4 counts of perjury, forgery, and tampering with physical evidence, arising from her conduct in Owens v. Eckert. On November 4th, 2025, a Maricopa County grand jury returned a second indictment, adding 6 additional felony counts arising from similar conduct against another victim prior to her meeting with Mr. Eckert. The original charges were dismissed without prejudice and brought again in consolidation with the November 4th indictment, plus 1 additional charge relating to Eckert. The consolidated case number is this. Again, he just builds and builds and builds. This is Omar charges Mike $500 an hour, and that is with a discount. Now, the difference between Omar, who I believe is at least $750 an hour, and an attorney like, say, Gindras, just look at the legal writing. Compare this to the absolute horse shit Gindras produces. That's the difference between a $750 an hour attorney and an attorney who works for peanuts. Because peanuts is all he can charge. K. The bankruptcy filing and its disposition. On December 8th, 2025, 33 days after the dismissal of a renewal petition, Petitioner filed a Chapter 7 voluntary petition in the United States Bankruptcy Court for the District of Arizona. On the same date, Petitioner signed, under the penalty of perjury, an application to have this Chapter 7 filing fee waived, declaring, "I currently have no income and no ability to pay the filing fee. I'm fully dependent on family for basic living expenses and cannot afford to make payments now or within 120 days." The Honorable Brenda K. Martin granted the fee waiver on December 27th, 2025. Oh, Serenity says, "You say peanuts is all you can charge while I put a peanut in my mouth." Timing! All right. On January 9th, 2026, creditor Clayton Eckert filed an adversary complaint for non-dischargeability of debt against petitioner, pleading 2 counts. Non-dischargeability of the $196,076.32 in fee judgments under this section for willful and malicious injury, and ineligibility for any discharge under these sections for asset transfer and concealment, destruction of or falsification of financial records, knowing and fraudulent false claims, and unexplained loss of assets. On February 12th, 2026, the United States trustee filed an application for examination and lodged a proposed order seeking to compel 3 years of tax returns, financial account statements, asset sale records, insurance, loan, storage, trust, and Sherry Tech debt records, identifying by name accounts held by Quartet Farms LLC, Lizmax Investments LLC, Keybacker Incorporated, and Stylet LLC. On February 23rd, the bankruptcy court signed an order extending the United States trustee's deadline to file an adversary complaint to deny discharge. On April 15th, 2026, before the Rule 2004 examination occurred, and before United States trustee filed its Section 727 complaint, Petitioner stipulated with the United States trustee and Mr. Eckert to dismiss the bankruptcy case with prejudice and not to refile any bankruptcy petition for 1 year. The court retains jurisdiction to reinstate the case if petitioner violates the bar period, in which event the United States trustee retains the right to conduct the Rule 2004 examination and file the Section 727 complaint within 60 days. Petitioner did not obtain a discharge. And he writes this as we went through yesterday on that stream, because Laura Owens, in her appeal, says, "I'm currently in bankruptcy. Poor me, I'm so broke. Well, that doesn't apply anymore. And she did it because she wanted to avoid the bankruptcy court, and the U.S. trustee to find out she actually has money. She's just pretending to be broke. The case law implicating petitioner's conduct. The governing statute, Family Code Section 6344. Family Code Section 6344 provides that the court shall issue an order for the payment of attorney's fees and costs for a prevailing petitioner. Subdivision B provides that the court may issue an order for the payment of attorney's fees and costs for a prevailing respondent only if the respondent establishes by a preponderance of the evidence that the petition or request is frivolous or solely intended to abuse, intimidate, or cause unnecessary delay. Subdivision C requires the court to first determine, pursuant to Family Code Section 270, that the party ordered to pay has or is reasonably likely to have the ability to pay. The amended statute became operative in January 1st, 2023. Respondent proceeds under subdivisions B and C. The amended section applies retroactively to this case. The Dragons v. Calkins holds that the amended version of Family Code Section 6344 applies retroactively to all cases pending on its January 1st, 2023. The frivolousness standard under Section 6344B. The two prongs of subdivision B are disjunctive. A fee award may issue on either frivolousness or improper purpose. The reigning California definition of frivolousness is the two-prong test in remarriage of flaherty, which holds that conduct is frivolous if it is either prosecuted for an improper motive, to harass or to delay, or indisputably has no merit, meaning any reasonable attorney would agree it is totally and completely without merit. The legislature adopted materially identical language in Code of Civil Procedure Section 128.5 Subdivision B2. The parallel statutory language supports applying the Flaherty test to the Section 6344B inquiry. The lodestar method governs reasonableness. Withdrawn motion hours are compensable. And this is reasonable fees and a lot of case law about hours. Fees incurred notwithstanding charitable funding. Yeah. This is Omar responding to Laura Owens. He had a fundraiser. California law. Let's see here, Lolly v. Campbell. A public crowdfunding campaign is squarely within the Lolly rule. Respondent's GoFundMe campaign is disclosed in candor to the court in the Serrato Declaration. Respondent remains contractually obligated on the fee balance. Any sums recovered will be applied first to the outstanding balance with the firm. There will be no duplicate recovery. The bankruptcy filing does not bar this motion. Petitioner's Chapter 7 bankruptcy was dismissed with prejudice on April 15, 2026, by stipulation. Yeah. Ginger ass over at X, you said, he's lying! He's lying in the... And then he cherry-picked one sentence. Well, problem for you, Ginger ass. He writes it all. Omar writes it all. And you have a good friend, and I don't know why, in Mark Randazza. Before you write anything, give him a call. I know you're here. Before you write anything on your fucking blog, before you say anything more stupid than you already have said, take a breath and call Mark. Let him help you as much as he can. Because now you're more or less pissing in his face. A man who tries to help you, and you're pissing in his face with every word you utter on social media. With prejudice. By stipulation, petitioner did not obtain a discharge and is barred from refiling for 1 year. Without a discharge, Section 524 discharge injunction has issued. Automatic stay terminated on dismissal. The pending appeal in this does not divest this court of jurisdiction over post-judgment fees motion, which is a collateral matter under Code of Civil Procedure and California Rules of Court. The fees motion is properly before this court. Yeah, regardless of what happens with Laura's appeal, they still can recover attorney's fees. G, the motion is timely. No written order signed by this court has been filed or served in this matter. Blah, 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 blah. Petitioner's conduct is worthy of section 6344. The true prongs of 6344 are disjunctive. Respondent established both by a preponderance of the evidence. A. Objective frivolousness. Any reasonable attorney would agree the renewal petition was totally and completely without merit. The petition omitted the core element of renewal. On the Family Code, section 6345 and Ritchie v. Conrad, a DVRO renewal required petitioner to prove an objectively reasonable apprehension of future abuse. Petitioner failed to do so. Petitioner left section 4A blank. The I'm afraid or worried that the person in 2 might abuse me in the future box is checked only section 4B, alleged violation. The accompanying 15-page declaration is titled Summary of Recent Violations by Mr. Marraccini. Its 46 paragraphs address past conduct. The closing paragraphs describe how respondent past acts have been absolutely terrifying and caused petitioner severe emotional distress. The declaration's final substantive request is for criminal prosecution based on respondent's violation. The 2025 petition alleges no direct interaction between the parties. The alleged recent violations recited in petitioner's 2025 declaration do not arise from any direct interaction between the parties. They center on petitioner's own Arizona paternity case, Owens v. Eckert. Mr. Marraccini's identification as a witness in that proceeding, his presence at June 10th, 2024 evidentiary hearing as a named witness, where, on petitioner's own account, court security and the sitting Arizona judge declined to exclude him. And the May 2024 release of 2016 through 2017 messages. Petitioner declined the witness stand and the cross-examination it required. The renewal turned on whether petitioner could establish, under Ritchie v. Conrad, an objectively reasonable apprehension of future abuse measured against conduct since the 2020 renewal. To carry that burden in the contested evidentiary hearing she herself had sat, petitioner would have testified live and been subject to cross-examination. Her direct examination would have anchored to the post-2020 conduct alleged in the 2025 declaration, conduct centered entirely on her own Arizona paternity case. Direct examination on that subject would have placed petitioner's credibility squarely in issue and opened the door to impeachment material Mr. Marraccini had assembled and disclosed in trial preparation. That material included 2 purported Sutter Health My Chart messages petitioner had produced as inbound provider correspondence, one dated 8/13/2016 from Yon Chung Kai Chan, MD, confirming a stage 1A ovarian cancer diagnosis. The other dated 8/31/2016 from Rebecca Yi, MD, confirming an oophorectomy and surgical abortion, both identified as forgeries by forensic examination. Even back then, in 2016, a decade ago, Laura Owens forged medical records. Via forensics and examination. If I remember correctly, Rebecca Yi has said, I didn't write that. Never wrote that. Don't know about Jan. I don't remember, at least. It also included contemporaneous equestrian competition records establishing petitioner's active participation in show jumping during the very period she has represented as one of continuing trauma, including her champion finish at the Scottsdale Fall Classic 2 within days of her life-threatening representation to this court. Petitioner had docket notice of the forgery exhibit from Mr. Marraccini's 8/25/2025 response over 2 months before the trial she had set. She did not appear at the hearing she herself had set. The federal and state records independently confirm the pattern. Following a June 10th, 2024 bench trial, the Honorable Julie Mara of the Maricopa County Superior Court found in Owens v. Eckert that petitioner, quote, brought the paternity action without basis or merit, testified falsely, misled the court, altered documents introduced into evidence, and acted with improper purpose. On August 19th, 2024, the court entered judgment for Eckert in the amount of $149,219. The Arizona Court of Appeals affirmed and awarded an additional $40,000 in appellate fees and costs by judgments entered May 6 and May 28, 2025. The Arizona Supreme Court denied review and awarded an additional $6,597 by judgment entered September 19, 2025. Petitioner's total fee judgment exposure on the Eckert litigation is $196,000.76. On May 1st, 2025, a Maricopa County grand jury indicted petitioner on 7 felony counts. On November 4th, 2025, a grand jury returned a second indictment, adding 6 felony counts arising from conduct against another victim prior to petitioner's meeting Eckert, dismissing the original indictment and recharging those counts in consideration. On January 9th, 2026, creditor Eckert filed an adversary complaint in the United States Bankruptcy Court for the District of Arizona, alleging that petitioner is ineligible for discharge. And there's a lot of paragraphs and examples and stuff here. On April 15th, 2025, the stipulated motion to dismiss with prejudice was entered, expressly preserving the United States trustee's right to file a Section 727 denial of discharge complaint upon reinstatement. No reasonable attorney aware of this record would have prosecuted this DVRO renewal. B. Subjective improper purpose. The October 2025 timeline proves the renewal was prosecuted to abuse, intimidate, and cause unnecessary delay. October 6, 2025. Entry closing date for the Scottsdale Fall Classic. The 2025 Scottsdale Fall Classic, a USF A-rated equestrian competition at Westworld of Scottsdale, Arizona, set Monday, October 6, 2025 as its entry closing date. The competition was scheduled for October 22nd through 26th, meaning she already knew. She had the trial date long before she entered that competition. She was never going to show up in person. Never. October 10th, 2025. Trial confirmed for October 21st and 22nd. The court resolved pre-trial motions, including denial of the Ginger Ass motion to intervene and the respondent's withdrawal to a CCP paragraph 470 of his motion, and confirmed trial dates. Confirmed trial dates. The trial dates were already there. This was confirming them. She already knew this was the trial dates that was set when she entered that competition. October 21st, 2025. Life-threatening travel representation. Petitioner appeared by Zoom and represented to the court that travel to San Francisco was life-threatening. The court ruled the motion was improper and not before the court today, and ordered petitioner in person for the following day. October 22nd, in camera continues to November 5th. Same day petitioner began competing. The court granted a brief accommodation continuance, finding the request improper and untimely, and ordered petitioner to appear in San Francisco and to be in the courthouse in person for the trial. The Scottsdale Fall Classic began on this same date. October 22nd through 26th. Petitioner competed and won. Petitioner was present at the Scottsdale Fall Classic on the very trial dates from which she had obtained a continuance based on representation that travel was life-threatening. She entered multiple hunter and equitation divisions, was photographed wearing back number 570 mid-class, and was named champion of the OR Sepp Hunter Derby, blah blah blah, riding Scirocco 91, a horse owned by Petitioner. The show producer's official Instagram account documented her on the winner's podium. Eyewitness Christine Hardin, a professional equestrian, observed Petitioner at the Westwood facility on October 21st, 22nd, 24th, 25th, and 26th, 2025, and declared under penalty of perjury that at no time during that window did Petitioner appear fatigued, distressed, in despair, or experiencing any physical issue. Rather, she appeared happy, energetic, and smiling. November 5th. Petitioner did not appear on the continued date she herself obtained. On November 5th, 2025, Petitioner failed to appear at the trial she had set, twice been ordered to attend in person, and successfully continued to that date based on a representation that travel was life-threatening. The court dismissed the renewal. Petitioner registered for an out-of-state athletic competition by no later than October 6, 2025, 15 days before her October 21st representation to this court that in-person travel posed a life-threatening risk. She competed at that competition on October 22nd through 26, 2025. She failed to appear on the continued date she had obtained on a medical incapacity record. Petitioner's claim that travel to San Francisco was life-threatening is further contradicted by her established pattern of obtaining travel authorization through proper channels in other proceedings. The Maricopa County Superior Court, Honorable Jeffrey Reuter, granted Petitioner's motion to modify conditions of release for travel to California on September 4 to 8, September 10 to 15, and September 23 to 26, and granted a second travel modification of motion on September 18, 2025, for travel to California on September 18 through 26. Petitioner was thus demonstrably capable of seeking and obtaining travel authorization in advance through proper channels when she chose to do so. When she chose to do so. Yeah. She's perfectly fine on traveling to compete, to visit family. She just doesn't want to show up in court. She doesn't want to show up in court when she knows she's gonna lose. C. Petitioner has formally announced her intent to file a new DVRO. Petitioner filed a notice of appeal on December 4th, 2025, a Chapter 7 voluntary bankruptcy petition on December 8th, 2025, supported by a sworn indigency declaration. Papers in the appellate court on January 20th, 2026, and an Arizona injunction against harassment against a third-party content creator on January 20th, 2026. On April 23rd, 2026, Petitioner filed an ex parte application for extension of time to file opening brief, which the First District Court of Appeal granted the same day. The filing is a 12-page, single-spaced document drafted and signed by Petitioner personally, in pro per. The application conclusions at Section 7 contains a formal written notice of intent to initiate further DVPA litigation against respondent. Petitioner hereby advises this court and places respondent on formal notice that independent of the outcome of this application, she intends to seek a new domestic violence protective order arising from respondent's recent and ongoing conduct. She is intending to continue the abuse of the judicial system and Mike. Hi, Henrietta. Her parents declared bankruptcy, are not paying their own bills, and yet continue to pay for Princess to ride ponies. If they had only learned to tell her no. Yeah, and by the way, her family, her mother and father, they tried to declare bankruptcy. They were denied. That case is dismissed because, shocking to absolutely nobody, they didn't want to produce documents. So it was dismissed. So no, they are not in bankruptcy court. They can't declare the bankruptcy, and now they're being sued by everyone. Everyone. Hey, thank you, Marilyn. Thank you for $5. This is for yesterday's live when you call her and see you next Tuesday. Bravo, Nick. Yeah, folks, I try to avoid it because YouTube sometimes demonetizes my streams because I use that word too much. So I'm trying to avoid it, but it's really, really hard to not call her that when she is a thunder. See you next Tuesday. In the worst possible way. Okay. The petitioner has the ability to pay. Here we go. Section 6344 and Family Code Section 270 require determination that petitioner has or is reasonably likely to have the ability to pay. The record reflects the following. Respondent's ability to pay showing is necessarily circumstantial. Full financial discovery against petitioner has not been undertaken. The cost of doing so in a post-dismissal posture would itself exceed the fee award sought, defeating the purpose of Section 6344C. Direct disclosure from petitioner is also not a reliable record. Petitioner has a documented pattern of misrepresenting her financial position when it serves her interest, including her sworn declaration of no income and no ability to pay the Chapter 7 filing fee on December 8th. A representation contradicted by her contemporaneous discretionary expenditure on USF National A-rated equestrian competition 6 weeks earlier. Yeah. They have to pay to enter. So, yeah, she has money. The court should therefore assess petitioner's ability to pay by reference to what petitioner has actually been observed to do with resources, what assets she has been federally alleged to control, and the demonstrated capacity to acquire and deploy resources across multiple simultaneous proceedings. The record on those metrics is substantial. Petitioner's October 22nd through 26th participation in the competition at Scottsdale Fall Classic on the very dates she had told this court were too life-threatening to travel for demonstrates discretionary expenditure capacity. Hunter Jumper competition at the US National A tier carries entry, stall, hauling, training, and lodging fees, supported by ongoing horse board, veterinary, farrier, insurance, and transportation expenses for the horse Scirocco 91 owned by petitioner. Petitioner's December 8th, 2025 voluntary petition checked no at Schedule AB Part 5 business-related property and disclosed no interest in any business entity. 5 weeks later, Eckert's adversary complaint identified Quartet Farms LLC, Lizmax Investments LLC, Keybacker Inc., and Stylit LLC as 4 entities petitioner controls or holds beneficial interest in, and pleaded the non-disclosure as a basis for Section 727 ineligibility. On February 12th, 2026, the United States trustee filed an application identifying the same 4 entities by name and demanding 3 years of records on each. The bankruptcy case was dismissed with prejudice on April 15th before any Rule 2004 production occurred, and before any Section 727 adjudication. The stipulated order preserved the United States trustee rights to file a Section 727 denial of discharge complaint upon any reinstatement. Petitioner did not obtain a discharge. So, she happily dismissed the case with prejudice, as long as she wouldn't have to disclose her financials. On December 8th, 2025, Petitioner swore under the penalty of perjury that she, quote, currently has no income and no ability to pay the filing fee and was, quote, fully dependent on family for basic living expenses. The same sworn application disclosed average monthly expenses of $4,077 and recurring family contribution of $2,750 per month. Eckert's adversary complaint expressly contrasts that representation with petitioner's previous statements made under oath. She has fucking $4,000 a month. Over 4,000 a month, as she claims as expenses. Okay. That is what some people make a month from work. Most people. So where the fuck does she get her all that money from? Petitioner has retained private criminal defense counsel in state of Arizona via Owens. Joshua Colsrud of Colsrud Law entered a notice of appearance on May 28, 2025 and represented Petitioner on a private pay basis until his motion to withdraw was filed November 17th. The period encompassing Petitioner's July 9th filing of the DVRO renewal at issue here, the October 21st and 22nd trial readiness hearings before this court, and November 5th trial date. Christian Loyders of Guardian Law Group, a private Phoenix criminal defense firm, has appeared as petitioner's counsel of record by notice of stipulated substitution of defense counsel filed March 3rd, 2026, and remains counsel of record to date. They don't work for free. She has money, or she gets money. Petitioner has continuously prosecuted and defended litigation across the San Francisco Superior Court, the matter at bar, the California Court of Appeal, the Maricopa County Superior Court, criminal civil harassment, and the United States Bankruptcy Court for the District of Arizona simultaneously. From respondent's retention of the Eagle Law Firm on or about July 9th, 2025, through the date of this filing, respondent has incurred merit attorney's fees of $90,100 and $100. Fees on fees of $5,850 and paralegal fees of close to $10,000. Documents cost of just under $4,000 and consist of firm advance costs, on one legal filing fees, printing and postage, certified copies, medical records, court filing fees, banker reporting and video service invoice, court reported cancellation fee for the October 22nd trial date, conf reporting invoice. It's a lot of cash. Fees sought in this motion reflect substantial voluntary downward adjustments before submission. A substantial amount of additional work was performed but not billed, including the independently incurred attorney's fees of co-counsel Rachel Juarez of Birch and Juarez LLP, which are not reflected in this firm's billing and are not being requested as part of this motion. Counsel incurred travel and lodging expenses for the in-person trial appearances are not reflected in the costs sought and are not being requested, notwithstanding the potential recovery under Family Code section, blah, blah, blah. Conclusion. Respondent respectfully requests that the court enter the proposed order filed concurrently. Finding respondent the prevailing party under Family Code section 633 and Code of Civil Procedure section 1032. Finding under Family Code section 6344B that petitioner's request to renew restraining order was frivolous and solely intended to abuse, intimidate, or cause unnecessary delay. Determining on the family code this and family code that a petitioner has or is reasonably likely to have the ability to pay. Awarding respondent in a total of $109,633.98. Reserving respondent's right to seek additional fees and costs incurred in responding to any opposition and in preparing and filing a reply. Ordering post-judgment interest at the legal rate from the date of entry until paid in full, and granting such other and further relief as the court deem just. I mean, this is amazing legal writing. Amazing legal writing. Oh. And here we have the exhibits. All right, index of exhibits for the hearing date of July 20th. Index of exhibits to respondent's motion. Exhibits, well, you have the billing statements, the mini minutes, burial forensics reports, previously filed full as Exhibit A to respondent's response to request, blah, 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 blah. Maricopa Grand Jury Indictment, Maricopa Grand Jury Indictment. Equestrian competition records. Horseshow.com show approvals page identify judges, course designers, blah, blah, blah. Horseshowing.com information. The show's official Instagram post. Action photograph. Petitioner's appellate filings. Notice of appeal. Designation of record on appeal. Banker reporting and video services. Wheels of Justice invoice. Yeah. That I can just, yeah, this is just the index. Exhibit 1. This is the billing statement. So this is the entries. And this is how it's properly done. I mean, this is, I remember from when Fannie Willis in Fulton County and her boyfriend, or toy boy, who was still married, when he submitted his invoice to Fulton County District Attorney's Office for his services, he clumped everything together. Yeah, this day I worked 24 hours in total and stuff like that. That's not how you produce those records. This is how you do it. Date, rate, amount, and description. Same here. Date, who, hours, rate, amount, description. And it goes on. 723, 724, 720. The amount of hours and for what? Attorney work product. See? And it keeps going. Details. Why? Because he's a good fucking lawyer. And it keeps going because, and here's the thing that is infuriating to me, is that this would have been so much cheaper for Mike if Laura had just gone to the hearings and to the trial. It would have been half of this. But Laura Owens' only interest is to hurt people. Hurt Mike. Postpone, lie, cheat, forge, perjuring herself as long as Mike hurts. That's her purpose. Because she believes she will get away with it. But the walls are closing in, Laura. The walls are closing in. So this is a lot of details. A lot of details. Yeah. Every day, every hour they did. And then also cost and expenses. This goes outside. This is outside of the lawyer's fees. The filing fee, printing, postage, and mailing costs for response. Filing fees, court filing fees, third-party vendor invoices, and stuff like that. And this is, for example, when an attorney does pro se, and then afterwards they still demand money. Well, the pro se is their hourly fee. It does not include stuff like this. And that is how they can get awarded fees from the court, even though they are pro se. It is for everything else. Filing fees, if they have to call an expert to the witness stand, that goes also outside of it. And that is what is meant by that, if anybody wondered. And the notes for that. So that was Exhibit 1. Exhibit 2 is the mini minutes from the hearings in California, which, surprising to nobody, Laura Owens never includes in her filings. She just refers for, it's not in the minutes, but she doesn't reflect it. So there's a lot. How do I do this? Oh, it's still mini minutes. Okay. Exhibit 3. The Berry Hill forensic reports, referenced only, previously filed in full as Exhibit A. Reference only, the full, blah, 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 blah. The court is respectfully directed to the prior filing. And that is, hey, what Laura presented to the court back then, forgeries. So the court already has it. Exhibit 4, the grand jury indictment. I did these way back when it happened, when we knew about it. But these are fun to read. Count 1, Laura Michelle Owens, on or between May 17th, 2023 and June 10th, 2024, pursuant to scheme and artifice to defraud, knowingly did obtain a benefit from Clayton Ray Eckert by means of fraudulent pretenses, representation, promises, or material omissions. Count 2, Laura Michelle Owens, between these dates, with intent to defraud, did falsely make, complete, or alter a written instrument, to wit, sonogram, in violation of Rs. 13/2002. Yeah, all of those. Yeah, she forged sonogram. Count 3, Laura Michelle Owens, on or about October 25th, 2023, in regard to a material issue, and believing it to be false, did make a false sworn statement to it, testifying in front of Judge John Doody that she had not been intimate with anyone else since March 2022. Yeah, she lied. Because, she claims she went to New York and got raped. which I believe, nah, never happened. She wasn't raped. She just went there, find a poor dude, had schmecks, and now she screams grape. Because that is how evil she is. Count 4. Laura Michelle Owens, on or about March 1st, 2024, in regard to a material issue and believing it to be false, did a false sworn statement to it, claiming that sonogram image was hers during sworn deposition. This sonogram image is one of the most evil things she has ever done. She stole the sonogram and story from a woman who actually lost a child during she was pregnant. She was pregnant with twins, and one of the twins died. She stole that story and that woman's sonogram. A few months ago, I read her story on a stream. Let me just say this: if Laura goes to trial, and this woman goes up to the stand and testifies, the jury would want to give her life in prison. Now, the charges doesn't allow that, but how can you be so... How can you... By what right did Laura Owens steal this woman's story and sonogram? By what right? Well, because she doesn't care. She doesn't care because she's never been pregnant. She's never lost a child. She's never had a miscarriage. She's never had it. So she can't fathom how that hurts in the woman she stole the sonogram and the story from. And this is what makes me absolutely loathe her, Laura Owens. Way back when, me and my ex, we are talking about almost about 20, 25 years ago, we tried. And we tried. And we had heartbreaks where a positive pregnancy test, and then a very bad period a month later, also known as a miscarriage. And it happened several times. She cannot fathom that feeling because she's never had it. And even if she... I don't think she can. Yeah, as Marielle says, other people aren't real to her, just background actors in her life story. Yeah. All right, let's continue. Count 5. Laura Michelle Owens make a false sworn statement to wit video clip of father touching pregnant belly. Yeah, that was her sister's, when her sister was pregnant, presented to the court. But she cropped the head off and claimed, no, that's me. That's my father touching my belly. No, never was. That was his sister's video she stole. Count 6. Did make a false statement to it claiming that's me showing my pregnant stomach. False. Count 7. Laura Michelle Owens, with intent that it be used, introduced, rejected, or made unavailable in an official proceeding which was then pending, or which Laura Michelle Owens knew was about to be instituted, did destroy, mutilate, alter, conceal, or remove physical evidence to wit. Exhibit 5. A question, Exhibit 5.1. Horse shows approval page identifying judges, course designer, steward, and blah, blah, blah. So here it is. Yeah, here's the horse show. Here's the judges, designers, stewards. It's approved under the Equestrian Federation and all of those. Exhibit 5.2. Information screenshot confirming, blah, blah, blah. Rating and entry closing date. Yeah. Scottsdale Fall Classic, horse show staff, da. This is, yeah. You have to get here before, well, get your application in before October 6th. 5.3. Instagram post. That's her. Laura fucking Owens. Presenting her award as she was first place finisher as she competed in the junior division under one of these exemptions. Yeah. She competed and won against 12-year-olds, robbing them of that experience. Now, she has now aged out of that exception, so she can't compete in that age division anymore. Yeah, yes, Maria, that's the kiddie riding competition she won. Yeah. And here is Laura Owens and Scirocco 91. Hillary George and Gueldorado. She stole that victory from Hillary George. She stole the podium place from Kira Saylor. Ugh. 5.4. Action photograph from Over Fences Photography showing rider on dark back, blah, blah, blah. 5.17. Oh, yeah, there she is. That is 1 or 2 days, either the day of or the day after she was supposed to be in court, which she claims she couldn't be at because of a life-threatening illness. Exhibit 6. Petitioner's appellate filings, Court of Appeal, blah, 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 blah. Notice of appeal, here that is. Designation of record of appeal. And all of that. 6.3. Civil case information statement confirming that no information confirming at item 2B that no notice of entry was served with attached minutes of November 5th, 2025 dismissal. This the appellant who claims, yeah, shit. Let's see, this is an email. Let's see what that says. All remote appearances are conducted through Zoom in accordance to San Francisco. The court has appointed Heather Bautista. Petition, yeah. This is, petition is not present. Respondent is present. Non-appearance. Da. Exhibit 7. PEMCA reporting and video services. This is the court reporter they hired to be at that hearing, November 5th hearing. Exhibit 8, Wheels of Justice, for I'm not sure here. What is it? Court filing of ex parte RFO package. Exhibit 9. Yeah, here is the full day in person court reporter services, which cost them $2,000 because they really wanted the hearing to take place, and Laura didn't show up, even though she the day before knew that she was supposed to be there, and then she invented a new medical emergency. Exhibit 11, Declaration of Christine Hardin. Let's see here. This is the woman who saw her at the equestrian show. Christine Hardin, declare and state as follows. I'm over the age of 18. I'm submitting this declaration in support of the respondent in the domestic violence restraining order renewal case. I am a professional equestrian and the owner-operator of Christine Hardin Stables. I've been competing at the Grand Prix show jumping level for over 25 years. I operate a training facility in Portola Valley, California, and regularly attend equestrian competitions and events throughout the country, including at Westworld of Scottsdale. On October 21st, I was at Westworld of Scottsdale for the Fall Classic. At approximately 3 p.m., I observed Ryan Miller, a horse training in the Phoenix area, riding a horse named Scirocco 91 in the covered jumper area. Scirocco 91 is owned by Laura Michelle Owens. I noticed a thin female with a high ponytail and green top near Ryan during this time. Based on my observations the following day, I believe this was Laura Owens. On October 22nd, at approximately 11 a.m., I saw Laura Owens at the Westworld facility. I am certain this was Laura Owens, as I had a clear view of her face and body. Laura was watching Ryan show Scirocco. And she was wearing a green hoodie, demeanor and behavior. Laura didn't speak to anyone other than her trainer, which I thought was unusual behavior. Laura arrived in a black Hyundai Tucson with a pink license plate. I was sort of going in and out of this vehicle multiple times. Laura remained at Westwood for approximately 1 hour. Friday, October 21st, I observed Laura at Westwood accompanied by the individual I later recognized as her mother, Jan Black. And keeps going. So yeah, so not only is there photo evidence, you have a declaration of a person who was there and saw Laura Owens. So Laura Owens cannot, to this court, says she has had a medical emergency October 21st and 22nd. Definitely not a life-threatening one. Plenty of evidence against that. And let's see here, Exhibit 12. We are only at page 83 out of 214. These are the... She wanted to be released for travel, yada, yada, yada. A lot of those. Exhibit 13. This is the transcript of the hearing. Petitioner's life-threatening email to the court. Oh, this is interesting. This is what she claims. She provided the court with medical documentation. Dear supervising family law judge and ADA coordinator, I have a long cause hearing in my domestic violence restraining order scheduled to begin tomorrow. At today's hearing, where I appeared on Zoom in Arizona, Judge Gold stated that if I do not appear in person tomorrow, my restraining order will be dismissed, even though the court's own October 10th minute states that the court strongly suggests in-person appearance. No. The judge clearly told you, be here in person. There's simply no getting around it. Which I understood to be advisory, not mandatory. I've submitted medical documentation establishing that travel or in-person attendance poses a life-threatening risk. My expedited request for reconsideration of motion to continue, filed October 17th, which is attached, included a letter from Dr. Colleen Green stating that in-person attendance would be life-threatening for her. Oh yeah, by the way, Colleen Green is a nurse, I believe she's a psychiatrist nurse practitioner, not a medical one. There is also an additional letter from Dr. Nassef requesting that the court make accommodation for postponement of her required duties at this time. And attached is the letter, which is, redacted. Dr. Green letter, also redacted. And then you have the bankruptcy compound exhibit, voluntary petition and schedules. This is where she claims, where she didn't cross in. No, this is the one in where she claims she has expenditures for over $4,000. Let's see, where is it? This is in. I had so much fun going through this way back when. Let's see if I can find it. Well, she claims she only has assets for just under $20,000. Filed for bankruptcy. Dun, 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 dun. She has a Hyundai Tucson 2021. Current value of the entire property, $13,000. Current value of the portion you own, $17,000. Now, the value of the Hyundai Tucson, if she sold it, is $13,000. She still has $17,000 to pay. Yeah. She has an iPhone, $600, horseback riding tab. Yeah. So these are her assets. But I want to get to where she claims what she spends her money on. If I haven't gone through it already. These are the debtors. Where is it? Yeah, she owes everybody money. No, not that one. Co-debtors. Sorry for... Oh, here, your income. Not employed. Zero. But let's see if I can find it quickly. Yeah, here. Family support payment that you, a non-filing spouse or a dependent regularly receive, including alimony, spousal support, child support, maintenance, divorce settlement, and property settlement. Yeah, family support. That includes money from mom and dad. She wrote zero. But later in a hearing, they give her $2,500 a month. Plus, she pays nothing to live in the gazebo. Nothing. And now, your expenses. She doesn't pay taxes, blah, blah, blah. She paid $445.39 for telephone, cell phone, internet, satellite, and cable services. Food and housekeeping supplies. $1,800 she claims she spends on food and housekeeping supplies per month. $1,800. How the fuck do you spend $1,800 on per month on one person? How? Folks, I'm just under 6'4". I'm just under 300 pounds. I spend at absolute maybe $400 a month. Laura Owens claims she spends 4 times as much on food and housekeeping supplies as I do. I assume food and housekeeping supplies for her includes Botox and horse tranquilizers or whatever shit she puts in herself. But sure as hell she doesn't eat for 1,800 unless she has a spoonful of caviar each morning. Chris says, don't think that's for her horses. No, this is only for her food. The horses are her assets are in a separate column. She might have meant it, but here's the thing. The stable she rented hasn't been paid, so they are wanting money from her. The place she gets horse food from, she hasn't paid them either. So they also, in the bankruptcy case, said, give us fucking money. She doesn't pay anybody. Clothing, laundry, and dry cleaning, $225. Personal care products and services, $100. Medical and dental expenses, $0. Entertainment clubs, $250. And she claims she only spends $50 a month on gas. Why? Because mom and dad gas up her car. Yeah, this is insanity. Absolute insanity. All right, let's get to the next set of exhibits. As you see, bankruptcy is a whole fucking lot. Exhibit A, 16B. Yeah, this is the trustees application. Examination and request for production of documents. Yeah, documents from her banks and credit unions. The 4 companies she has interest in, their banks, their credit unions, or everything going back 3 years. And all of a sudden, Laura Owens was very, very interested in, no longer interested in filing for bankruptcy. Because I believe that would show they are funneling money from their accounts to somewhere. But the walls are closing in, Laura. Walls are closing in. I think I went through this as well a few months ago. Yeah, a request for production of documents, which she never did, of course. 16.3, notice of lodging, proposed order granting. Yeah, this is from the bankruptcy court. I've gone through all of this in previous streams. Oh, request to renew restraining order. When Does your current restraining order expire July 9th, 2025? Has the order been renewed before? Yes. How long do you want the restraining order to be renewed for? Permanently. Reason for renewal? Check all that apply. I'm afraid or worried that the person in two might abuse me in the future because no reason, not checked in. She only claims, yeah, 4B, the person in two has violated the order. See attached declaration. So she knows exactly which ones they are crossing in. She knows exactly which one she crossed in and which one she hasn't. And this she never did because she's afraid or worried that the person in two might abuse me in the future because whatever can she make up to put in there that won't sound absolutely retarded. Yeah, see the Exhibit 19. Stipulated motion to dismiss with prejudice. The United States trustee and creditor Clayton Eckert, by and through their respective undersigned counsel and debtor Laura Owens, debtor proceeding pro se, hereby stipulate both of them and move the court for an order voluntarily dismissing the above captioned Chapter 7 bankruptcy case with prejudice to refiling for 1 year, subject to the terms and conditions set forth herein. Yeah, she self-banned herself from filing for bankruptcy for a year. Debtor filed a Chapter 7 bankruptcy petition in this case on December 8th. Debtor filed a petition pro se. And no attorney has entered an appearance on her behalf in an administrative bankruptcy case. Now, Ginger has tried, but the court basically told him to fuck off. In very, very nice, dry words, told him to fuck off. January 9th, Clayton Eckert filed an adversary complaint against debtor. February 12th, the court granted the application for federal rural bankruptcy procedure. February 23rd, yada, yada, yada. In order to resolve the issues presented by the bankruptcy filing and potential denial of discharge action by the UST, the parties have agreed to the following. Voluntary dismissal. Debtor agrees to voluntarily dismiss her above captioned Chapter 7 bankruptcy case pursuant. Agreement not to file. Debtor agrees she will not file a bankruptcy petition in any U.S. bankruptcy court for a period of 1 year from the date of entry of the order of dismissal in this case. Consequences of violation, reinstatement of the case. And yada, yada, yada. And this was submitted April 15th by Clayton's attorneys and Laura Owens pro se. So she can't file for bankruptcy until 4/15/2027. Yeah, JKD, but he was told, get thee forth and fornicate thyself forthwith. Exhibit 20, adversary complaint for non-dischargeable debt. That is Clayton, adversary complaint for non-dischargeability of debt. Just to make sure that the bankruptcy court said, yeah, in this bankruptcy, all of a sudden you don't owe Clayton any money. So he was avoiding that via this motion. and yada, yada, yada. Exhibit 21. Yeah, sworn indigency. Signed under penalty of perjury December 8th, 2025. Order granted December 27th, 2025. Remember, this was at the time she competed. She went on vacations. With what money? During this time, she hired an attorney in the criminal case. With what money? So this is her claiming she is butt-ass broke. Which we know, yeah, she claims she has over $4,000 in expenses. And here, this is interesting. Regularly pay any of these expenses. Yeah, her parents pays her $27.50 monthly. Remember from a bankruptcy case? Where she declared she had no income whatsoever. Laura Owens, this here is income. Staying in your parents' home for free, that's a declarable income. Having them pay your car insurance and car payment and gas, that is an income. And yada, yada, yada. Exhibit 22, email thread with Department 405. Court's confirmation that no notice of entry was served and court's reservation of July 20th, 2026 hearing date. April 13th, Mr. Serrato would like to request a court date for Mr. Serrato's motion for attorney's fees. Motion is available already. These dates can work. Court will reserve only up to 2 hours, usually 1 hour for this issue. Please advise. Good morning. Can you provide dates in July, August? Yada, yada, yada. Exhibit 23. The Chan and Ye forged my chart letters. Purported Sutter Health my chart messages. Identified by the Berry Hill forensics examination as fabrication. Folks, if you never read or heard this amount of bullshit, what Laura Owens claims is doctor's notes. To Laura Owens from Yeonshun Kai-chan. Dear Laura, thank you for your email. I am sorry you're going through such a rough time right now and will do my best to help you through it. I'll read the messages you sent me from your boyfriend and answer his questions. If he did that, this is a HIPAA violation. Stage 1A is without a doubt considered to be true cancer and something that we take very seriously. You are correct, Laura, that this cancer is found only in one ovary. It's incorrect in saying that this means you just might have malignant cancer cells. Please tell him that yes, I have diagnosed you with real ovarian cancer, not something that just may be there. I'm not sure what is meant by the message you forwarded that says I would only be diagnosing it if it was something other than stage 1A. That is very real stage and simply means it has not spread beyond your right ovary. I recommend looking at the American Cancer Society's website page for more information. Not a doctor in history would write bullshit like this. Why would they need to when all Laura Owens had to do was show the medical records? Why this bullshit? Well, because there was never medical records of this. She had to fabricate this. And now through a forensics examination, this is concluded as a forgery. And then you have this. In addition, you can let it know that your diagnosis and treatment has been complicated by your pregnancy. There was never a pregnancy. Which on its own has been extremely difficult and unusual. I strongly encourage him to change his attitude and support you at this time. I sincerely hope things get better. What an absolute... This is so absolute bullshit. Not a doctor in history would give relationship advice. They have better things to attend to, like saving lives, than to write, not only go through a bunch of texts and then make this reply. No. First of all, they can't bill for this. Seriously. It's so stupid. It's so stupid. And here is the Rebecca G letter. Yesterday, 8/30/16, you received an ovary removal surgery, oophorectomy, on your right ovary, as well as surgical ending. Due to your recent medical history, I will wait to confirm pregnancy termination until blood work and a follow-up ultrasound are completed. Although there were no complications during the procedure. As you explained to me, you have already experienced emotional side effects, such as extreme fatigue, depression, and mood swings. These are common, and I would ask your boyfriend to support you during recovery. Again, not a doctor in history would send this out. They would refer to your medical records. Show me your medical records. I don't have time for this. Stop calling me. That is what an actual doctor would say. Fuck off. You have your medical records. Show him. This here, absolute bullshit. And now through forensics examination, shown to be absolute bullshit. So already from 2016, going forward for almost a fucking decade, she has defrauded men through fake pregnancies. From 2016 that we know of. She was 25 then. And she's a full-blown forger and scammer. I can bet money this started when she was a teenager and then evolved from there. Exhibit 24. Petitioner appellant's ex parte application for extension of time to file opening brief. Yeah, this is this I have. I believe I already read this in a prior stream. Yeah, I read this yesterday. Go to yesterday's streams if you want to see me curse the ever-living fuck out of Laura Owens. So I won't read it again because I already read it to you yesterday. It was so much fun. It was so much fun. Okay, so let's get to... Oh, that's the final one. That's the final one. All right. This is insane. This is insane. This is now her forgeries in the 2016 case against Mike Marraccini. I believe now it's outside of the statute of outside of the statute to prosecute her for, but it can still be used in both the civil appearances and in the criminal court, because if I remember correctly, and I think I do, she is charged as a repeat offender, first time court, which is an Arizona thing. Meaning they can bring up every piece of garbage, if approved by court, every piece of garbage she has done to men in her entire life. If that shows a modus operandi. That will be interesting. The only thing in all of this, because she will suffer consequences, legal consequences for this. The problem is that all this shit that she has done, she will still be, if convicted, she will be sentenced as a first-time offender, which means, sadly, probably no jail time. That's the harsh truth of it. What speaks against that is all the shit she has done to people for the past decade. Yeah, thank you, Jen. Statute of limitations. Thank you. That's the word I was looking for. And yeah, I know she's still out on bond on on her own recognizance. She still gets to go on vacations. And I did the calculation out of the 14 counts. What is the absolute max she can get? And it depends on the judge. But if she get it to, if they can allows it to stack on top of each other. Now, a bunch of them can't be stacked against each other and has to be go concurrently. But I still believe the absolute max she can get is 30 years. I don't think that, but that's just, that would be so amazing, but that won't happen. My guess is she, if convicted, she will get probation. And with that, Mike, Clayton, Greg, and any other victim can apply for a permanent stay away, a permanent restraining order from the get-go. Let's see, Kristen. If you haven't read it, I can't believe it. She's still out walking. Yeah, I agree. Folks, if this wasn't a case where we could read the shit she has done, and I've read emails, I've covered all the things regarding Laura Owens. You could not imagine such a horrible person exists. This Laura Owens is of the same type as Amber Heard. She's of the same type as what's her face? Sarah. Sarah Boone. She's of that type of person. Histrionic. Type B personality. Who for everything is about her, and everybody who wrongs her, she believes, in my opinion, that it's okay for her to forge. It's okay for her to lie because they deserve it. It's okay for her to lie to the court about it because they deserve it. It's okay to drag people through courts because they deserve it. The only person these guys deserves peace from Laura Owens. And here's another prediction. It won't help. She will continue to do this from jail, from probation, from everything. Because she believes they deserve it. I'm sorry to say this, but I don't think she will let go. Mike, Greg, Clayton, she will keep doing this to them for the rest of her days. And all the other guys. And she won't care if she's in prison. She won't care if she's on probation. She doesn't care if she has to do it being homeless. She won't stop. She won't stop. That's the sad truth about people like her, like Laura Owens, Sarah Boone. Amber Heard, and the likes. They won't stop. Hopefully there will be enough hinders in the way so these men can move on. So her trying to get to them becomes part of the white noise, background noise. But I would not be counting on it. I will not be counting on it. But she provides content. It's fun to make fun of her. But women like her, and some men, hurt people. If I were to go through a number of these cases, that is not Laura Owens. I mean, Sarah Boone killed her guy. Amber Heard almost sent Johnny Depp to prison. They will, because they use abused women as a shield. They are abused, I can pretend to be one too. And it's heartbreaking. Carolyn Grayston, Lori Wallow Daybell, yeah. Lori Wallow killed children. There are numerous of the same type of person, numerous examples, who make it harder for real victims of abuse to be believed. All right. Yeah. Folks, this has been great. This has been great. Thank you for I thought I heard Mr. Jingles. Or the cat door, at least. Folks, thank you. Thank you for allowing me to do this. Thank you for showing up. Thank you for the super chat. And please watch my other videos, because this guy here eventually wants to retire and relocate to the United States. And to do so, I need fuck off money. And I don't say, oh, give me all your cash. No. Watch my stuff. I promise it's good. And you know it's good. Snark attack. Folks, every damn video, snark attack. All right, folks. And tomorrow, slightly buzzed show. And we will go through what have happened lately in the Karen Reed case. We will watch a hearing, we will read some motions, and then we will have a drink of choice, me and some friends, and just have fun. Just have fun. So I'll see you tomorrow at 5 p.m. Again, watch my other stuff. Big Nick needs monies. All right, folks, that is what I had for you for today. You all have a great day, and I will see you guys in the next stream or video. Bye-bye.
Laura's got a secret, oh what a tale. She spins a wild story, set to sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're...
Oh, whoa, sorry. Thank you to Diana for $30 via PayPal. That is so nice of you. I didn't see it until now. Sorry if you got away from me. And again to Diana, another $10. Lots of love from Montana. Oh, thank you. Thank you. Yeah, all right. Yeah, I didn't see that until now. Okay, now, off you fuck. Bye-bye.
Laura's got a secret, oh what a tale. She spins a wild story, set to sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now, but truth's got legs and it's taking a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dream.